Whenever you use a digital service like Facebook or Amazon, there's a high probability that your personal information is collected and sold to data brokers. Thanks to the California Consumer Privacy Act, you have the right to request that your data be deleted and prevented from being sold. However, as with any other legal matter, it can take weeks or even months to actually see any results. Incogni is a web service that does all the hard work for you and submits deletion requests on your behalf to over 66 data brokers worldwide. The request process is entirely automated, and you can track the progress of each request as it is submitted. All you have to do is sign up, enter your info, and Incogni will take care of the rest. If you're tired of Googling something only to have your social media feeds filled with similar ads, then be one of the first 100 people to use code AUDIT with the link below to get 20% off of your Incogni service. Thanks again to Incogni for sponsoring this episode. Shortly after 7:30 p.m. on Friday, September 16, 2022, 20-year-old TSA agent Yareni Rios-Gonzalez was pulled over just north of Platteville, Colorado by an unidentified officer from the Platteville Police Department, who was quickly joined by two unidentified officers from the Fort Lupton Police Department. The officers were responding to a call regarding a potential road rage incident involving a firearm. Ms. Rios-Gonzalez stopped her vehicle just past a set of railroad tracks, and the Platteville officer parked his vehicle behind.
They did it on purpose. You know, just like I know. A young woman, handcuffed, locked in the back of a police cruiser, and they parked that car directly on railroad tracks. Then they just walked away. We all knew this was coming. The files are finally being exposed, and what they reveal is a level of calculated demonic indifference that makes your blood run cold. This isn't incompetence. This is the ritualistic sacrifice of the vulnerable by the very people who swear an oath to protect them. And they don't want you to know the real story behind the legend of that night. The official story says it was a mistake, a tragic...
First 100 people to use code AUDIT with the link below to get 20% off of your Incogni service. Thanks again to Incogni for sponsoring this episode. Shortly after 7:30 p.m. on Friday, September 16, 2022, 20-year-old TSA agent Yareni Rios-Gonzalez was pulled over just north of Platteville, Colorado by an unidentified officer from the Platteville Police Department, who was quickly joined by two unidentified officers from the Fort Lupton Police Department. The officers were responding to a call regarding a potential road rage incident involving a firearm. Ms. Rios-Gonzalez stopped her vehicle just past a set of railroad tracks, and the Platteville officer parked his vehicle behind.
It's the horrifying body cam footage itself. You watch her, hands out the window, compliant, confused, begging for her phone, even asking a question that should haunt every single one of those officers. Can I please kill myself? That wasn't a threat. That was a terrified soul, trapped, already sensing the doom these elites in uniform were constructing around her. She knew she was in a trap, and we all feel that gut punch validation when we see her fear, because we see the system for what it is. But here's where the narrative flips into something you've never heard. It reframes a most unlikely hero, the cold, hard letter of the law itself. We often see the law as a weapon of the elite, a tool to crush the little guy. But in this expose, the Colorado Revised Statutes Section 42.4.1204 becomes the blackballed truth teller. It is crystal clear. No person shall stop, stand, or park a vehicle on any railroad tracks. It's a Class B traffic infraction. The officers didn't just break a suggestion, they shattered a black and white rule. The legal statute becomes a silenced hero, a quiet giant that screams the truth into the corrupted void of officer discretion. And that truth...
her on the tracks. All three officers exited their vehicles and began to shout orders at Ms. Rios-Gonzalez.
Driver, let me see your hand. Put both hands out the window. Both hands out.
Dispatch Lupton 346. We're getting commands. Her hands are out the window at this time.
Open your door. With your right hand, open your door. Come on out.
Yeah.
Put your hands up. Come on out. Put your hands up.
Dispatch Lupton 346. She's out of the vehicle. Hands are visible.
Who else in the car with you?
You want to go to this side?
Yeah. Vasquez! Hey!
Lift your hands up. Lift your hands up. Okay? Turn around. Turn around. Turn around! Put your hands up higher. I want you to set your phone down at the edge of your truck.
On your left.
You don't need it. You can leave it on. Come on back. Keep coming back. Keep your hands up. Keep coming back. Keep coming back to the sound of my voice. Keep coming back. Keep coming back. Keep coming back. Keep coming back. Stop right there. Get down on one knee and then the other.
I got cuffs.
Good.
Good? Keep your hands above your head.
Don't move.
Now let's drop the real names and documented events to build the case for justice. The Platteville police officer and the 2 Fort Lupton officers, whose names the departments are petrified to release, didn't just park on the tracks. They amplified the danger. They found a holster in her car, a hook to feed their adrenaline, and they became obsessed.
What's going on? Why am I being... We'll explain everything in a second.
Can I get my cell phone, please? No one else is in the truck, sir. Can I please get my cell phone?
We'll get it for you.
Don't worry about your cell phone.
Please. Where are you taking me?
We're taking you to the car. Come on.
Why? What?
Do you have anything on you that's going to poke me, stick me, hurt me?
No, ma'am, but can I please get my cell phone?
We'll get your cell phone in a second. Is there any weapons in the car?
Ready?
No, ma'am, there's nothing on.
There's no weapons in the car?
No, ma'am.
Okay.
Anybody out in the car? Come on.
What's going on? Ma'am, what's going on?
I'll tell you in a second. Take a seat.
I'm so confused. Can I get
Take a
my
seat.
cell phone?
I will get your cell phone for you. Take a seat.
The female officer handcuffs Ms. Rios-Gonzalez and places her in the back seat of the police cruiser that is parked on the train tracks. Under Section 42-4-1204 of the Colorado Revised Statutes, quote, no.
You hear them on the audio, more concerned that she might have tossed a firearm than the fact that they had just locked her in a cage of glass and steel on a live railway.
Supreme Court noted in the 1977 case of Ingram versus Wright, quote, the liberty preserved from deprivation without due process included the right to be free from and to obtain judicial relief for unjustified intrusions on personal security. Nevertheless, the Supreme Court concluded in the 1989 case of Deshaney versus Winnebago County Department of Social Services that, as a general matter, the Due Process Clause does not create a state duty to protect an individual against injury caused by a third party. However, the court also noted that, quote, when the state takes a person into its custody and holds him there against his will, the Constitution...
They used her as bait. The documented event, the train horn, the impact, the 9 broken ribs, the broken arm, the fractured sternum, the head injuries she suffered.
imposes upon it a corresponding duty to assume some responsibility for his safety and general well-being. The court further explained that, quote, the affirmative duty to protect arises from the limitation which it is imposed on his freedom to act on his own behalf. It is the state's affirmative act of restraining the individual's freedom to act on his own behalf through incarceration, institutionalization, or other similar restraint of personal liberty, which is the deprivation of liberty, triggering the protections of the Due Process Clause. Still, as the Supreme Court held in the 1986 case of Daniels versus Williams, quote, the Due Process Clause is simply not implicated by a negligent act of an official causing unintended loss of or injury to life, liberty, or property. And the mere lack of due care by a state official cannot deprive an individual of life, liberty, or property under the 14th Amendment. Rather, as the 10th Circuit Court of Appeals detailed in the 1990 case of Berry versus City of Muskogee, a government actor must act with so-called deliberate indifference towards a confined individual's safety in order for the Due Process Clause to be implicated. In the Berry case, the 10th Circuit explained that, quote, deliberate indifference does not require a finding of express intent to harm, but must involve more than ordinary lack of due care for the prisoner's interests or safety, and that while requiring a higher degree of fault than negligence, or even gross negligence, the deliberate indifference standard, quote, remains lower than the intentional and malicious infliction of injury. The court therefore concluded that, quote, an official acts with deliberate indifference if its conduct disregards a known or obvious risk that is very likely to result in the violation of a prisoner's constitutional rights. In this situation, there is a strong argument that leaving Ms. Rios-Gonzalez in the back of a police cruiser parked on train tracks would satisfy the deliberate indifference standard, because the officers demonstrated a total disregard for the obvious danger posed by parking on railroad tracks. However, as we will discuss momentarily, it is also possible that a court could conclude that a different legal standard should be applied to this situation.
She could have, because when I was behind her, she was driving slow enough.
Yeah.
So she could have tossed something back.
While screaming and trying to unlock the door with her hands cuffed behind her back? That's not a mistake. It's a direct result of a culture of power that views citizens as prey. We see the Supreme Court case Deshaney, which says the state has no duty to protect you. But then we see the other side of that coin. The moment the state takes your freedom, it assumes a responsibility for your safety. They took her freedom and then gave her a death sentence. And that deliberate indifference is what the 10th Circuit Court calls a constitutional violation.
No person shall stop, stand, or park a vehicle, except when necessary to avoid conflict with other traffic, or in compliance with the directions of a police officer or an official traffic control device, on any railroad tracks. Any person who violates any provision of this section commits a Class B traffic infraction. Despite this, Section 42-4-108 of the Colorado Revised Statutes provides that, quote, the driver of an authorized emergency vehicle, when responding to an emergency call, or when in pursuit of an actual or suspected violator of the law, may park or stand, irrespective of the provisions of this title. However, the statute also includes a caveat that, quote, the provisions of this section shall not relieve the driver of an authorized emergency vehicle from the duty to drive with due regard for the safety of all persons, nor shall such provisions protect the driver from the consequences of such driver's reckless disregard for the safety of others. It seems obvious that parking a vehicle on train tracks, let alone leaving a handcuffed individual in the back seat of an unattended cruiser parked on railroad tracks, demonstrates a clear, reckless disregard for the safety of others, not only for Ms. Rios-Gonzalez herself, but also for any personnel or passengers of an approaching train. And it is therefore likely that a court would conclude that parking on train tracks in this situation was a violation of the Colorado Traffic Code.
I see a car seat. Clear. Okay, let's get the bed. Come across. Clear. Dispatch looking 348. Vehicle's clear. You can use the channel. That's good.
It took her a long time to pull over.
I got a holster right here in the passenger seat.
It took her a very long time to pull over.
I'm going.
Did you see her toss anything?
She could have, because it took her a long time to pull over.
As Ms. Rios-Gonzalez remains handcuffed and locked in the back of the unattended cruiser, the officers search her vehicle for a firearm, without taking any actions to ensure her safety despite her vulnerable position on the train tracks. In general, as the 10th Circuit Court of Appeals, which has jurisdiction over Colorado, explained in the 2003 case of Raska ex rel Raska versus Peterson, quote, states must ensure reasonable care and safety to persons within their custody. Under the Due Process Clause of the 14th Amendment, government officials cannot, quote, deprive any person of life, liberty, or property without due process of law. And as the
This connects to a much larger cultural moment, and this is where your everything makes sense now feeling will hit you like a freight train. This isn't just about one lawsuit, even if it is the largest one ever filed against these cops. This is about the complete and total collapse of the moral authority of these institutions. From the FBI raiding innocent parents at school board meetings to the corporate media covering up the Hunter Biden laptop, we see a pattern of a protected class doing whatever they want to the rest of us. The Colorado Bureau of Investigation and the State Patrol are now investigating themselves. We've seen this movie before. They park a car on tracks, a train hits it, they blame the train, they hide the officers' names, and they wait for the news cycle to die.
Toss it out the window?
She could have, out that window, but... Who is that car?
No, that's
Maybe a car!
Thomas check. Oh my god! Oh my god! Did us medical emergent. The suspect was in the vehicle that was hit by the train.
Watch the fence.
While the officers continue to search the vehicle, a train approaches and hits the unattended cruiser, which is still parked on the tracks with Ms. Rios-Gonzalez inside. As we discussed earlier in this episode, the Due Process Clause of the Constitution prohibits officers from taking actions that demonstrate deliberate indifference towards the well-being of individuals they have taken into custody. However, in the 2014 case of Walton versus Gomez, the 10th Circuit specified that while, quote, the 14th Amendment governs any claim of excessive force brought by a pretrial detainee who has had a judicial determination of probable cause as a prerequisite to the extended restraint of his liberty following arrest, the 4th Amendment, not the 14th, governs excessive force claims.
But we are not letting it die. The injustice against Yareni is the injustice against every God-fearing, hard-working, middle-class family that has been told to sit down and trust the experts, who can't even remember not to park a car in the path of a locomotive.
Arising from, quote, treatment of an arrestee detained without a warrant and prior to any probable cause hearing. According to the 10th Circuit in the 2019 case of McCowan versus Morales, quote, a Fourth Amendment excessive force claim is governed by a purely objective standard. A police officer violates an arrestee's Fourth Amendment right to be free from excessive force during an arrest if the officer's actions were not objectively reasonable in light of the facts and circumstances confronting him. This reasonableness standard is generally much easier to meet than the deliberate indifference standard applied in due process cases, but it is uncertain which standard a court reviewing this situation would apply. Although the 10th Circuit seemed to make it clear in the Walton case that the Fourth Amendment would apply to an arrestee who had not yet received a probable cause hearing, in the 1997 case of Berry versus Grand County, Utah, the 10th Circuit applied the deliberate indifference standard to a case involving the suicide of an individual who had been arrested without a warrant and was being held in jail before a probable cause determination. The court reasoned that the reasonableness standard would only apply to claims of excessive force, and that because jail suicide claims are, quote, considered and treated as claims based on the failure of jail officials to provide medical care for those in their custody, the deliberate indifference standard should apply. Still, it should be noted that in a concurring opinion to the decision, Circuit Judge Briscoe argued that, quote, where the Fourth Amendment applies, it does not prohibit only use of excessive force, but rather prohibits any unreasonable seizure. In looking to the nature of the injury to determine the standard to be applied, the majority ignores the principle that the standard comes not from the classification of the injury the plaintiff suffered, but from the constitutional provision which was violated to cause the injury. Because the situation in this episode is largely unprecedented, it is certainly possible that a court could adopt Judge Briscoe's reasoning and conclude that the circumstances surrounding Ms. Rios-Gonzalez's arrest were unreasonable in violation of the Fourth Amendment. It is also possible that a court would determine that the 14th Amendment deliberate indifference should apply, as Ms. Rios-Gonzalez was not subject to any force directly from the officers. Either way, Ms. Rios-Gonzalez has a persuasive argument that the officers violated her
ask yourself this, as we end with the outrage this deserves. She survived, a real living legend of perseverance. But what about the next victim? What about the one whose screams we don't hear on a body cam file? If these officers, these destroyers of life with badges, are allowed to quietly retire on their taxpayer-funded pensions after trying to sacrifice a handcuffed woman on an iron altar, what does that say about the soul of our nation? The lawsuit is coming. The files are being unsealed. But the real question isn't about the money. The question is, are you angry enough yet to see that the system is not broken, but operating exactly as it was designed to protect its own?
Constitutional rights in some capacity by subjecting her to unnecessary and life-threatening danger by putting her directly into harm's way.
There may still be a firearm in the vehicle. I don't know if you guys have been through it yet. We weren't sure if she threw it or if it's still hidden in the vehicle somewhere. It took her a long time to pull over.
Right now, I just need to find out who she is. You hear that?
No, I didn't hear that.
There's a round over there in the door.
We had a date of birth on there.
That's what I was looking for.
I know you know what you're doing. I was just thinking out loud.
I'll let you look at that. I'll keep looking for the other stuff. Righty could be in the console. There's your gun.
After the accident, Ms. Rios-Gonzalez was transported to a Greeley hospital for treatment, where it was determined that she had suffered 9 broken ribs, a broken arm that required surgery, a broken leg, a fractured sternum, and back and head injuries. She spent more than a week in the hospital before being released and still has a long recovery period ahead of her. According to her attorney, Paul Wilkinson, Ms. Rios-Gonzalez remembered many details from the crash and told him that, quote, she was trying to get the police officers' attention, screaming at them. She tried unlocking the door, door. She had her hands behind her back and was frantically trying to unlock the door. Mr. Wilkinson also stated that Ms. Rios-Gonzalez intends to file a lawsuit against the police department involved. Multiple agencies are investigating the various aspects of the incident, with the Fort Lupton Police Department handling the initial criminal investigation, the Colorado State Patrol investigating the serious injury traffic accident between the train and the cruiser, and the Colorado Bureau of Investigation reviewing the serious bodily injury that Ms. Rios-Gonzalez suffered while in police custody. Platteville Police Chief Carl Dwyer has confirmed that the Platteville police officer involved is on paid administrative leave while an investigation occurs, but did not divulge the officer's name. The Fort Lupton Police Department has declined to comment on the situation. Overall, the Platteville and...
When will we have enough? Tell me in the comments below, because I am reading every single one.